this is 3847 2015 cyclostyle decision of the Grahamstown Eastern Cape Division per Bloom J, where he encapsulates what Rule 615 of the Uniform Rules of Court says, which reads as follows: the court may, on an application, order to be struck out from an affidavit any matter which is scandalous, vexatious, or irrelevant, with an appropriate order as to cost, including cost as between attorney and client. The court may not grant the application unless it is said that the applicant will be prejudiced in this case if it will not be granted. Let's now go back to the first and foremost issue of the pair. Have they convinced the court that there's any prejudice? They have not. All they've done is they've just done a volte-face of bringing this application orally so, without identifying any prejudice that they will suffer. They've not identified none whatsoever prejudices before this court, not even in their heads. They don't bring what prejudice that they will suffer should that matter not be struck out from the counter applicants' affidavits and also the answering affidavit. None whatsoever. They've not even proffered even an answering affidavit to the counter application as to the reason why that matter should be struck out. So on the issue of prejudice are no longer shame. They have not exhibited any prejudice before this court. There's no prejudice, therefore. Then I go to the next issue that the court needs to look at when it's dealing with the issue of application to strike out. Also, if you look at it, my lady, the next issue is the information irrelevant? That's the next scope. Because remember, we've addressed you on the issue of prejudice. We now refer you to the issue of are these issues irrelevant? They're not. These are matters that concern live litigation between parties, which Vexmans brought erroneously against the 8th and 9th respondents, and they've sought again to erroneously bring the same litigation to the fore in this matter. So that cannot be, because these two respondents are remotely connected to this case. So that remote connection ought to have been a sound clarion call to the SABC, SIU, and their Vexman's attorneys in tow that they should not bring this litigation against this pair. This litigation was frivolous and vexatious against the 8th and 9th respondents. It is for these reasons, my lady, that we seek a punitive cost order of cost de bonis propis against Mrs. Kosima Basu. She ought to have been aware that you can't employ an incompetent legal strategy to bring and hold before the court two former employees of the SABC just because you want to settle a certain vendetta. That cannot be, my lady. I don't know, my lady, if you now want me to address you on the issue of costs. Because remember our Jermaine, the raison d'etre for our costs is slightly different from all other respondents, my lady.
Yes, you may proceed.
Thank you, my lady. My lady, the Vexman's attorneys, they've abused the court platform or the tribunal platform to score vendettas against the 8th and 9th respondents. And this court should frown upon such conduct. And the only way and manner in which to frown upon such conduct is to find Ms. Kosima Basu or her law firm, Vexmans, or jointly and severally with her law firm, that you can't victimize and act in a callous manner towards the respondents. Because remember, the objectives of the tribunal are quite clear. So what Vexmans has done is they've gone roughshod in this matter. And remember, like I said to you earlier in our arguments, that the pair are organs of state, and they are therefore the guardrails of the Constitution in terms of Section 165(4) of the Constitution. They are therefore supposed to abide by the Constitution, not to utilize it for their nefarious ends, like what the pair has done in conjunction with Vexman's attorneys. It is in this aid that, my lady, that I think a cost order de bonis propis ought to be occasioned on Vexman's attorneys, particularly Ms. Mabaso. My lady, we have referred you to the cost de bonis propis arguments, and I'll give you a reference to our heads, so that I don't want to take up the tribunal's time, because I understand there's my learned brothers and sisters who are awaiting their cue to also ventilate their argument before this court. My lady, if you look at this issue, I just want to quickly go to the last rank, the issue on the, it's under the subheading, the reckless conduct of the SABC, SIU officials and their legal team, and the issue of costs. I've said to you, my lady, the pair, I've referred you to the Kelland decision, where I said government is not an indigent nor bewildered litigant adrift on a sea of litigious uncertainty, to whom the court must extend a procedure circumventing lifeline. It is the Constitution's primary agent. It must do right and it must do it properly. End of court. So that's what I'm saying, that they should not just have brought this application in a mischievous manner in which they did. They were supposed to do right and do right to the 8th and 9th respondents, but they did not do that. They did not hear that clarion call, which clarion call had earlier been also echoed in Grootboom versus NPA, which is the 2014 decision, my lady. And I also referred to the Public Protector versus South African Reserve Bank decision, and also the Matatiele municipality decision. And also, I want to refer you, my lady, to the case of Mashishi versus Matladla, NO and others, where Van Niekerk say that you can't bring an application when you know that this application is a dead-end bit. And this is what they did with, they should not have done that. My lady, I don't want to bore you and spend more time on this. This is clear in our heads why we seek cost bonus profits. But I now want to go to another rank where we're seeking on the issue of Mrs. Maria Dreyer, with the deponents of these affidavits, the issue of the perjury, my lady. That's one of the unenvious tasks which awaits you. This is in terms of paragraph 180 to 184 of our heads, my lady. I'm saying that she should not have misled this court. So if she has misled this court, and if it is to be found that her evidence on oath were all lies or misrepresentations, then this court must display its wrath and direct a copy of the tribunal's judgment to the National Director of Public Prosecution to consider whether Mrs. Dreyer lied under oath, and if so, she should be prosecuted for perjury. I've referred you to the Batabile Dlamini matter, which is the Black Sash decision. I've put it as by way of footnote in our hands, my lady, to assist you in addressing the issue of perjury. It's in footnote 99 on page 015-61 case lines, that is section 15 of case lines, my lady. My lady, there's another further issue, my lady, where Mrs. Maria Dreyer and Mr. L commissioned affidavits of the finance officers of the SABC, knowing fully well they were investigating these matters. That, my lady, is a violation of the Commission of Oaths Act, and I've also made an invitation to this tribunal to ensure that the pair, that is Ms. Maria Dreyer and Mr. L, are referred to the Minister of Justice Constitutional to see if whether they should be, their capabilities of commissioning affidavits should be withdrawn, given the manner in which they've acted in the commissioning of affidavits, my lady. Unless if there's something else that you wish me to address you on, my lady, those will be our brief submissions.
Thank you, Mr. Kufa. Mr. Hidita.
Thank you, my lady. My lady, as you're well aware, I act for the sixth respondent in this matter, Mr. Tebele. My lady, I'll also be very brief. I intend to deal with 5 issues. Issue number 1, I'll deal with the issue of unreasonable delay. I'll deal with the affidavits, and simultaneously with that, I'll deal with the issue of the applicants making out a case in reply in respect of certain of the relief that they seek. I'll also deal with the issue of the Operations Committee terms of reference, which we submit as the 6th respondent have no force within the SABC. And then finally, we'll deal with the merits and why there's no case against the 6th respondent. My lady, as we've indicated in our heads of argument, The sixth respondent takes no issue with the review relief. And similarly, we align ourselves with the approach adopted by the seventh respondent. We only oppose the repayment relief. We've also indicated, my lady, that, well, starting with the issue of the delay, in our respectful submission, my lady, we submit that there are unexplained periods for why there was a delay, and on that reason alone, you should find that there is actually an unreasonable delay. I mean, you've got the authority for that in SIU versus Engineered Systems Solutions, which says that if you can't account for the entire period of the delay, then that delay is in fact unreasonable. So having known at the very latest, and as indicated by my learned colleague for the seventh respondent, the SABC knew from the 13th of September 2017, when the forensic investigation was conducted, that the payments were irregular, they breached the PFMA, and that members of the OPSCOM need to be held accountable in this regard. So what we're saying is that there was then a few weeks later an EXCO meeting, which then resolved that the payments to the legends should cease. So at that particular point, we respectfully submit, my lady, that the SABC did nothing. And even when the SIU was appointed a few weeks prior to that, there's actually no explanation as to what the SABC itself did, other than to say that no, they took a back seat because then the SIU took over the investigation. So we respectfully submit that for those 3 years, and also given the fact that when the interim board took over this matter in March, or when the interim board was appointed in March of that same year, March 2017, there's also no indication as to why the forensic department only took 4 to 5 months to conclude its investigation, yet the SIU took more than 3 years to conclude its investigation, other than to say that no, there were various other matters that they were dealing with. And even then, my lady, there's also no explanation as to why, having concluded the investigation in June 2020, there's a further period of 6 months before the application was lodged, other than to say, well, yes, my lady.
Sorry, can I extend the same request to you, not to
yes, my lady.
I've actually followed a very different approach in adjudicating this matter, because normally I direct parties what they should address me on.
Yes,
I've given you the link here, which has taken us the whole day.
Yes,
because I've done. So please don't be repetitive.
So, my lady, what I'll then, I know that my colleagues have addressed you on the issue of the unreasonableness of the delay. They've also addressed.
You can just clarify the context in which you would like me to consider that issue on behalf of your client, given that she's considered the review.
Indeed, my lady. My lady, there's an argument that there's no delay, there's no prejudice to the sixth respondent. We respectfully submit that that cannot be the case. The sixth respondent has indicated that he's a pensioner. There's also, as I've indicated, a failure to account for the entire delay. So I think on that basis, and taking into account his personal circumstances, it cannot be said that he will not be prejudiced by you overlooking any delay that may have been explained, even though we all know that the delay has not been explained, my lady. My lady, I don't need to deal with the issue of the affidavits. The affidavits are meant to define the issues between the parties as well as place evidence before the court. Where this becomes relevant for the sixth respondent is that the sixth respondent actually challenges the terms of reference of the operations committee. And they do so on the following basis, my lady, and they say so in their answering affidavit, their supplementary affidavit. They say that the operations committee terms of reference were never signed and they were never approved by the board. And what has happened here, my lady, is that we've been given a policy management framework. You'll find that at 0052198, and you'll see at 0052112 that the OPSCOM terms of reference were never signed. But importantly, what the policy management framework says, my lady, and that's clause 1.6.2 thereof, it says no policy will have official standing at the SABC unless the steps formalized in this policy management framework have been followed, the end product formally approved and signed, and the policy communicated to staff. Now, my lady, clause 2.5 of the policy management framework says that all policies must be approved by the SABC board, and that during the approval process, presentations need to be made by the board, and then after sign-off, the compliance department would actually then manage the rest of the life cycle of the policy. Now, our submissions in this regard is that the applicants have failed to dispute the fact that the operations committee terms of reference are unsigned. In fact, it is admitted, and it's also not disputed that those OPSCOM terms of reference are unsigned. We also say that following the decision in SABC versus Kiwi and others, if the policies have no force, then the principle of legality finds no application. Now we're saying, my lady, that the provisions of the policy management framework are quite clear. We cite the case of Indumeni, which I don't need to do here, and which is also well known. And then we're saying, my lady, that these operations OPSCOM terms of reference are of no force at the SABC, and our clients should not be bound thereby. In response, and in their replying affidavit, the applicants then say, well, you waived your right because you were a member of the OPSCOM and you never raised these issues before. With the greatest of respect, my lady, a waiver is it's objectively determined. There has to be an intention from the sixth respondent to waive his rights in that regard. There's no case that's been made out for such a waiver, and none has been proved either. There's no evidence to support that allegation, and this case has never ever been pleaded that the sixth respondent actually waived its rights in that regard, my lady. So, my lady, I would respectfully submit that on that score, my lady should find that the operations committee terms of reference, based on clause 1.6.2 and clause 2.5 of the policy management framework at the SABC, should be found to be of no force and effect, and therefore not binding on the sixth respondent. My lady, I'll then deal with the case that's been made out against the sixth respondent very briefly. My lady, the sixth respondent states that the issue of the legends was dealt with very briefly at a meeting of the Group Exco on the 26th of July, but that no resolution was taken at that meeting. He further indicates that the issue of the music legends was also not a part of the agenda, and the minutes of that meeting actually also show that the discussion was off the record and it was no longer part of the meeting. Now, as I've indicated, or as my other colleagues have indicated, the applicants appear to rely on the sixth respondents being a member of the OPSCOM without any evidence that it was actually part of any decision that was taken at that particular meeting. And in this regard, my lady, we respectfully submit that this version is actually supported by the seventh respondent when she says the following in her affidavit. On the applicant's own showing, the meeting was impromptu, called at the last meeting by Motsoeneng, and there were no meeting packs distributed to the OPSCOM. There was no vote taken at that meeting. My client, the sixth respondent, also indicates that he never voted on this issue of the legends because there was nothing that was actually put to vote. He also indicates various issues why the minutes of the meeting were problematic, or why the meeting itself was problematic. We deal with those in paragraph 74, including the fact that there was no agenda, no notice, no submission packs, no formal apologies noted, and also the fact that the minutes of this particular meeting were actually approved almost a year after the meeting itself. However, my lady, we've also indicated that we do not take any issue with regard to the review relief. All the sixth respondent takes issue with is the repayment relief. My lady, I deal briefly with the issue of costs, and I align myself with the arguments made by Mr. Badlander on behalf of the seventh respondent that when determining the issue of costs against public officials, you have to look at whether they acted in a flagrant disregard of constitutional norms in a high-handed manner and whether they played the victim in the litigation. My lady, in Black Sash, as also indicated, the test is bad faith and gross negligence. There's nothing on the papers, and certainly nothing's been pleaded to show that the sixth respondent acted in bad faith in this manner, that he was grossly negligent. We all know what the rationale for this is, because it would dissuade public officials from actually taking any decisions, and this would have dire consequences on the public interest. My lady, to the contrary, the applicants contend that they contend that the first respondent, Motsoeneng, knowingly misled his colleagues and the SABC and persists in his affidavit to give false information as to the source of the funding. Now, if on the applicant's version, the sixth respondent was misled together with other colleagues, such a version is actually very much at odds with the finding that the sixth respondent acted in bad faith or in a manner which was grossly negligent. We further submit and we repeat that the sixth respondent took part in no vote, and simply that there's no basis in holding him personally liable for costs incurred in this Legends matter. And that would be even if the pleaded grounds were established, which we deny. So, my lady, we respectfully submit that taking all of those into account, it would not be just and equitable that the sixth respondent should be held personally liable for the costs and also for the repayment relief over and above the issues of prescription, unreasonable delay, as well as the other points in limine which have been raised by the other parties. And also the issue that my lady raised with regard to the personal liability and the clause that my learned colleague seemed to rely upon, which was clause 5.2.3. So, my lady, we respectfully submit that the sixth respondent is a pensioner, and with other members, they were led to believe that there was funding which would come from private funders externally, and moreover, the authorization of the payments was as a result of a business case, which the sixth respondent was never a party to. The business case was approved, supported, and requested and supported by the first, second, and 10th respondent. And we respectfully submit, my lady, that on the basis of the submissions that we've made, that there is no case against the respondent, that the claim against the respondent should be dismissed with the cost of counsel, my lady. And my lady, unless there's any submissions which you would like me to address you on or anything further, those are the submissions for the sixth respondent, my lady.
Thank you, Mr. Hita.
Thank you, my lady.
My lady, may I, on behalf of the 10th respondent, Mr. Aguma, present the submissions as fully set out in his heads of argument. My lady, having the benefit of listening to the colleagues on various matters raised, which are also similar to the arguments set out by the 10th respondent in his answering affidavit and captured in the heads of argument. My lady would see that the heads of argument dealt with specific issues like delegation of authority, unreasonable delay, just and equitable remedy, and prescription. There's also a question of locus standi, my lady, that we do not intend to pursue. So, given the fact that the issues relating to the delegation of authority, unreasonable delay, I'm indebted to my colleagues who have made such compelling submissions on these issues. I would straight go to the issue of just and equitable remedy, my lady, but I will be very brief on that issue. As I was listening to your ladyship engaging with my learned friend, Mr. Butlander. My lady, the just and equitable remedy, which is imposed by the Constitution, with respect, does not suggest that your ladyship would then, in terms of exercising that, have a discretion or authority to go against the provision of the statute. I say this, my lady, because as we set out in full in page 15 of our heads of argument, we dealt with the issue of just and equitable remedy, and we link that issue within the context of the prescription submissions that we have made at page 20 of our heads of argument. At paragraph 35 of our heads, we have cited the authority of Mtokonya versus the Minister of Police, where the issue of prescription has been extensively dealt with by the Constitutional Court. And we have cited various authorities, my lady, from page 20, 21, 22. I do not wish to repeat those authorities as they are clearly set out in the heads of argument of the 10th respondent. As I've submitted earlier, my lady, the narrow argument that the 10 respondents is making to you is that in terms of 1721B, it can't be that the just and equitable remedy would mean that the court would disregard the provisions of the Prescription Act. That is not so. And my lady, you would note that the extensive authorities in regard to that point, they also do point out that just and equitable is of course based on justice, fairness, and the interest of justice overriding that. And my lady, I would submit that there can never be any justification in the name of the interest of justice or fairness that would mean that your ladyship should not apply the prescription provision on the basis that section 172 1B empowers your ladyship to make an order which is just and equitable. So, my lady, as alluded by my learned friend, Mr. Butlander, without repeating the submission. It is not correct, my lady, that the provisions of 1721B are such that in the present case, where there are allegations of so-called unauthorized payments to the music legends, and therefore, as a result of that, your ladyship is invited to make an order that the participants in that decision, as set out in the notice of motion, I think the last paragraph of the notice of motion, should bear a cost jointly and severally. We don't find, my lady, any legal precedent that allows your ladyship to interpret just and equitable, to ignore statutory provisions. And we therefore submit, in short, my lady, that the statutory provisions enjoin your ladyship to come to a simple conclusion, even if your ladyship is inclined to grant the review. But your ladyship is therefore not legally permitted to therefore make an order that the disbursed money should be recovered from the respondents as mentioned in the notice of motion. So, my lady, in short, 10th respondent wanted to just make such narrow submission, and in total, we 10th respondent aligns himself with submissions made by other respondents on various issues. Without repeating those, my lady, we 10th respondents align with those submissions, as please the court.
Thank you. Thank you, Mr. Mancho. Mr. Mamabulo, I think you are last. Mr. Mamabulo.
May it please you, my lady.
Yes, how long are you going to be?
My lady, I do not think that I will be longer than 3 to 5 minutes. And yes, my lady, this is so because
I'd like to see you. I can't see you. If you could please switch your video on.
I apologize. Yes, ma'am. Can the court see me now?
Yes, I can see you now.
Thank you very much. Yes, my lady, I do not intend to be long at all. In fact, my lady, I do not even intend to recite any of the case laws that have been cited by my learned friends, for which I am grateful. My lady, the second respondent aligns pretty much fully with the submissions as provided by my learned friends, particularly the 6th and the 7th respondents. And my lady, if we were to really stress and perhaps fortify on one of the issues raised by the other respondents, my lady, is in respect of the issue of prescription. Now, my lady would have seen from the second respondent's answering affidavit, as well as briefly dealt with in the heads, my lady, that the issue of prescription is simply inescapable for the applicants. And my lady, to fortify this, my lady, we have referred in our answering affidavit to section 77, subsection 7, 77.7 of the Companies Act, my lady, which simply provides, if I may get to it, and suddenly it escapes my computer. if I may briefly get to it, my lady, to read it into the record, although it is expressed in our answering as well. My lady, section 77 of the Companies Act specifically deals with the liability of directors, and my lady would have appreciation that this being a case of this being a case brought against the respondents in their fiduciary capacity of the SABC, that if any liability in their status as directors would arise, that this would be in respect of this section here. And now, my lady, to fortify, as I said, to fortify the submissions made by my learned friends earlier, my lady would have regard to the provisions of 77.7, and they read as follows. Proceedings to recover any loss, damages, or costs for which a person is or may be held liable in terms of this section may not be commenced more than 3 years after the act or omission that gave rise to the liability. Now, my lady, submissions has been made as to precisely when did this liability arise, all right? And there is a difference as to that being a point, that being from a point at which the decision was made, or a point at which the interim board became aware of the liability. My lady, we would submit that at best for the applicants, that the liability would have arisen at the point in which the forensic investigation was completed and the SABC was aware of the alleged irregularities, and therefore a liability in respect of the monies that they now seek to recover from the second respondents as well as others. And my lady, in that regard, not only has the claim prescribed in terms of the Prescription Act, but the Companies Act tells you so, my lady. It tells you that you cannot claim against directors for anything that is outside of a 3-year period. That, my lady, itself also speaks to the several of the issues that we have raised in our papers, for which I do not wish to, it's late in the day, I do not wish to repeat any of them. They have been repeated by others, but only to highlight, my lady, that we take issues, one, with the question of delay. We take issues with the lack of sufficient explanation provided by the applicants, that they do not tell this court why indeed it took them as long as it did to bring the review application. Now, in our heads, my lady, and in our answering affidavit, we cite several of the cases that have been used by others, my lady, for what the court is to take into consideration when dealing with the issue of undue delay. Now, I will leave, my lady, for on the submissions made out in the papers. However, my lady, just one thing to note out of that is that one of the considerations that the court would have regard to is the issue of interest of justice. Now, one, in this regard, might obviously want to have the court view the interest of justice from a point of view of seeking to impugn the liability as it does, because they would like to have this court believe that some nefarious or corrupt conduct followed this decision, which is not the case and which is disputed in the papers, my lady. The interest of justice, if the court were to consider all of that, our submission is that the court must go and extend itself around the issue of the decision itself. This is not monies that were allocated to the respondents in which they were taking money into their pockets or their companies or anything like that. This is money, as the first respondent submitted earlier, my lady, this is monies that were allocated for a particular reason to the legends, and justification were made around that. And now, whether that justification is correct or incorrect, my lady, we would submit that for around the interest of justice, it would not take the applicant's case any further, my lady, that a decision was made. Whether that decision was wrong at the time or not is something else. But this is not a decision that was taken in bad faith. This is not a decision that which the directors took for self-benefit. Furthermore, my lady, the other issue that we align strongly with, my lady, is the issue of a case made out in the replying affidavit, and that being of Section 523 of the delegation of authority to impugn this liability. My lady, we align fully with the submissions as made, that this is not a case that was advanced by the applicants. This is not a case for which the respondents have had any opportunity whatsoever to respond and to deal with. And last but not least, my lady, in our application, we take issue, my lady, with although this is more of a procedural issue than anything, we take issue, my lady, with the irregularity of the amendment of the applicant's case, my lady, and that being how this supplementary affidavit of theirs was brought about. My lady, we also raise issues, and I'm trying to summarize. We also raise issues, my lady, with non-compliance of the directives that were issued by this court in respect of Rule 30 and 30A, and all of those issues. Now, my lady, all of this is made out in the papers, and which I'm pretty much aware that my lady has read. And in the answering affidavit, my lady, we take point for point all the allegations that would directly impact on the second respondent. We address those directly, point for point, from around paragraph 41 of our answering, my lady, right through from 41 onwards. And if one is to pick highlights from those, my lady, one of the highlights would simply be the second respondent saying, but it cannot be correct that I would now suddenly become personally liable for a decision that, for all intents and purposes, was taken prior to my time as the acting chief financial officer. She tells my lady in the answering that firstly, she was employed by SABC in the same year of 2016, around February, as a general manager, and was seconded and appointed as the acting chief financial officer around June. And that at the point when some of these decisions, or perhaps proposals were presented to her, she tells my lady in the answer affidavit that she understood this to be discussions that precede her. That these were discussions that she was in any event not in a position to either block or question whatsoever. But more than that, my lady, she tells the court, she tells my lady in the answering affidavit that her supporting the business case is based purely on presentations that were made to him by the chief financial, by the CEO, Mr. Motsoeneng, as well as Mr. Aguba, and that her support itself does not amount to a decision. Whether that decision is wrong or right in respect of paying out of the legends is neither here nor there, my lady, but simply that her supporting the business case as the acting CFO at the time does not amount to her taking a decision. And furthermore, this was based on assurances given to her. This was based on assurances given to her that the funding for such a project would be sourced externally, including from MultiChoice. Now, all of those, my lady, as I say, are pleaded out in the answering affidavit from 41 going down. My lady, that would make our submissions, as I said, my lady, will align fully with what has been submitted by the other respondents. Firstly, we rely heavily, my lady. This application does not make it out of the hurdle. This application does not surpass the issue of prescription. The submissions made earlier by the applicants are not helpful. They have not challenged the constitutionality of the provisions of the Prescription Act. This is not a legal argument that can be made to say this is a public law species and cannot be addressed through common law remedies as in private law. No, my lady, prescription holds true to this application as it does to any other debt. And not only that, my lady, we have told my lady that this is in particularly to against the directors. This position is fortified by the Companies Act that says you cannot go against directors outside a period of 3 years, stated differently, easily any liability that arises out of any decision, out of any contract of directors, that liability, if there is a claim that is due to anyone, can only be exercised within a three-year period. Normally, that period has long gone and long passed. Earlier, I was making calculations as to the actual number of days, but I will not burden the court with such numbers. The fact of the matter, my lady, is that this is law. The 3-year period has passed, and the applicant cannot now on their feet seek to amend the law, and they have not challenged the validity of the prescription.
Do you have anything further, Mr. Mamabolo?
I do not, my lady. That will be all my submissions.
Thank you.
As the court pleases.
Mr. Motepe, would you like to reply now or tomorrow?
No,
You said
now, lady.
you'd like to reply now.
Be done in 30 minutes.
You'll do it in 30 minutes.
Yes, if it pleases the court.
Okay, other counsel, are you happy to proceed for the next 30 minutes? And then we've finished today.
Certainly, I am. Thank you, my lady.
Thank you, Mr. Bucklander.
Yes. Malady, I'm going to be quick.
Yes, my lady.
I'm going to be quick. Firstly, the issue of prejudice in relation to delay, and I raise this in my main argument. There are two issues. There is prejudice if the the decision itself is not set aside. And my argument was that in relation to that, none of the respondents have put up any reason why they will suffer any prejudice. The prejudice that they assert is only in relation to the just and equitable remedy. And I've made that very clear from the beginning. Even as I've listened to all my colleagues, none of them, in fact, most of them say, look, we don't take issue with the legality point, with the review. So they cannot therefore be raising delay in relation to that. Their delay, they may raise prejudice in relation to the just and equitable remedy. So that is a distinction. On the prescription point, Malini, everybody argues this, and I still cannot understand the base of the prescription point. But let us postulate. In 2017, the SABC issued summons to claim this monies from the legends. What special plea is being raised against them? A very simple one. That in terms of auditoral decision, the decision taken to award this legend payments, it stands in law until set aside. We are going to be hit with a special plea. So I still don't understand this argument that we could have brought a summons to claim those payments. We could not have. In law, you can't. Until the decision is set aside, it is valid and has got legal consequences. Simple as that. Let alone the issue we raised, that 172(1)(a), once there is that declaration, the court is not limited by private law. We still say private law remedies. The fact that it's prescription comes from statute does not make it necessarily public. It's still a private law remedy. If I issue someone for undue enrichment or for what, you can hit me with prescription, but not in this case. But and the fallacy lies in the fact that how could we have issued summons when the decision was still valid? And that should be the end of this matter, the prescription matter. But my lady,
Mr. Motepe,
yes,
how I understand the arguments that have been advanced by various respondents is prejudice in respect of prejudice as a result of the delay, and some of them have set out factors.
yes,
They have resigned
yes, and that I understand, my lady.
or retired. Sorry, some
Yes.
of them have already retired. They rely on very limited retirement funding. They've been battled to finance this litigation. A whole lot of factors that are cited to
Yes.
establish prejudice as
Yes,
far
no,
as the remedy.
Yes, no, and
Also,
that
I'd like you, if you can deal with the reliance on how the courts in Gijima and Buffalo City approached the delay point
yes.
in the context of the remedy.
Yes, in fact, I was about to deal with that. And truly, that is the point that they should be raising. the delay point in relation to just an equitable remedy and argue based on Gijima and Buffalo City. That they can do, no problem, but they cannot raise prescription point. That's the point that I wanted to make. But and your ladyship has already dealt with the Gijima case. In both cases, because we're dealing with service providers who had tendered openly and won tenders initially, the only issue was the extension of those agreements. So there was openness, there was accountability when the initial tenders were awarded. So the delay will always be linked with the kind of an impugned decision. And in Gijima, as your ladyship correctly pointed out, Gijima repeatedly asked assurances of SITA, and SITA said, no, you're fine. We have complied with all our SCM policy. In fact, in the contract that they concluded, there was a specific clause put in there where in the contract, Gijima put that clause in there to say, you as SITA, you have assured me that you have followed your SCM policies. That clause is there. But this is a service provider who had won a tender previously openly. Now, when there's an extension, he says, look, but assure me that you followed all the prescripts. So that is a distinction. We don't find that here. They may assert delay in relation to just an equitable remedy, but not in terms of the decision. What we heard from Mr. Butlander, he says, but it's EXCO that decided. And then you hear from for example, the 10th respondent in the papers and other 6th and 7th, they say, no, it's not us. It's not us, it was EXCO. But then you hear from others say, no, it was not us, it's OPSCOM. In fact, the 10th respondent specifically says OPSCOM had those powers. So you have parties trying to shirk a responsibility. But the issue is, let's look at the impugned decision. This is an unlawful decision. I've already taken your ladyship through that, where there was an allegation that our source fund from private sources. We don't find that in the business case. None of these respondents engage with that. None of them. So there's a clear distinction between what happened in Gijima and Buffalo City compared to what happened in this case. There is a clear distinction, and one cannot rely on those two cases to make a distinction here. Cannot. There's a very clear distinction. Now, the Mr. Butlander said that your ladyship could, on the basis of delay, dismiss this, and if we are being sued, because my point initially was that decision is still valid as we sit here. Until the leadership sets it aside, it's still valid. Then Mr. Butlander says, no, but we can still issue summons if your leadership is not with us. No, if the legends issue summons against us, we could still raise prescription, we could still raise a reactive challenge. But that is where prescription properly comes in, and they'll be able to explain that, but we're unable. And they can give all sorts of reasons. We're unable to come up until this matter that was pending before court is resolved. So it is not defense to say no, but even if we may be sued by the legends, we can still raise a prescription. Secondly, he says we could raise a collateral challenge, but we can't. A state organ can raise a reactive review, but the Merafong judgment makes it clear. Collateral review delay does not play a role because it is an individual being coerced by the state. For example, where there's legislation, you are being sued based on that act. Then collaterally challenge the act to say, but it was not properly passed. That's a classical collateral review. No delay is relevant. But the Constitutional Court made it clear in Merafong that where you're dealing with a state organ, what it brings is a reactive challenge, but it must still explain the delay. So what we are being told, while we're here, having explained the delay and having shown your lordship that in terms of the Buffalo City principles, we qualify, at least on the legality review, we qualify, we should be granted this order. You are being told that no, don't assist them. Let them go. If they are being sued, They will then bring a collateral challenge, again explain the delay. So your leadership is being asked to permit proliferation of actions unnecessarily when we're here, and none of them has explained why, at least the legality issue cannot be dealt with here. None of them have asserted a prejudice. Again, that prejudice is only in relation to the remedy. So those arguments do not hold. The first respondent, I'm surprised that there's still an argument that there were private funds sourced, and we're accused that, but we did not give evidence. The affidavit of Mr. Modau is at page 280. He is a general manager finance for corporate, so he speaks with authority. He attaches annexures, including financial statements. We have not been told why those are not sufficient to say what we say is the correct state of affairs. There were no private funds. You say that. And this argument still persists, and now we're told there's dispute of facts, there's oral evidence tendered, but there is no genuine attack. They've not engaged with the evidence. Then she says, Madam Fran says, we have not attached any confirmatory affidavit by any member of the board, presumably to prove Mr. Motsoeneng's argument that, but I did present this to the board and the board approved it. But clearly, we're referring to the 2016 board, even if that argument can hold. So how are we blamed for that? Because that board went its way. 2017, there was a new board. Why didn't Mr. Motsoeneng go and get a confirmatory from one of the board members who was a board member at the time to say, remember this happened on this date, and then he confirms that. You don't find that. Does not give details as to when he went to the board. And again, like I say, which board. So this point really, I'm actually surprised that it's still being persisted with in the light of all the evidence and the argument we presented. I've already dealt with it.
He's saying you should prove that there was no board approval because you are saying that there wasn't.
But how do we prove? To bring here a blank paper, because that is what we are required to do. If there is an approval by the board, there'll be evidence. We attach it. If there's no approval by the board, where do we get that evidence? Where do we get it? With respect, my lady, the argument is with respect absurd. We can't be expected to prove something that doesn't exist. We say so under oath, it doesn't exist, and that's it. You must prove that we're not telling the truth and so forth. She also argued that, okay, she argues that there was no approval made on 26 July 2016. The approval was on 5 September 2016. Remember, I said Mr. Butlender says the approval was not on 5 September 2016, but it was in July 2016. So respondents are pointing fingers at well, I would say at each other, but you see, and that's what you expect. If officials acted bona fide and they may have made a mistake, you expect them to come to court and own up and say, look, here we were misled, we made a mistake, but do not raise unmeritorious points simply to waste the court's time. Do not do that. You own up and tell the truth what happened. Clearly, you might have been misled, but you say so.
But doesn't Ms. Tugwana do that? She's saying as far as she's concerned, she wasn't approving anything. She was putting into operation what has been approved.
But what does the minute say? The minute of 8 September, it says approved. Now, if you believe something has been approved, why do you approve again? And surely, if there's an approval, there will be something before you showing that indeed there has been an approval. But there's none. But again, the minute, and I've taken a leadership through the minutes. 26 July minutes simply say we note on the legend mat. But the 5 September meetings expressly says we approve. That's the language used. So all these technical points, when the facts are so bare, so plain, instead of admitting, owning up, and we still raise all these technical points and wasting time. My lady, the 8th and 9th respondent, you know, there's been an attack on my attorney. There's been an attack of Werksmans. Again, if your leadership looks at the affidavit appears at page 003, 106, I'm just giving references. For example, we're told about cases that happen in the labor court, labor issues, and that's why we say this matter does not belong here. But we have all this, and you know, one takes umbrage at how my attorney has been attacked, that she's got a vendetta, she's got this, when you do not find the case being made out in the affidavits. What is it that you say she has done? What you are showing us is another attorney in Werksmans who deals with labor issues, who fought with or who brought cases or whatever, unrelated to this matter, labor issues, who are being harassed with all those cases and being told that there is a vendetta now by Ms. Mabas. How? When she was not party to these cases. And why do we make these allegations against her and now seek a punitive court order? When you have not even made a case in the affidavit and you are so liberal with the language, uses nefarious, terms like nefarious and vendetta, one really takes umbrage to that kind of, and that is not how, but in all that attack, the dead silence is you do not hear response to the case that we're dealing with before court by the 9th and the 8th. And the 8th respondent is being sued here. But she's happy to simply rely on she doesn't file an affidavit. I must not confuse the two. He doesn't file the affidavit. He relies on an affidavit by his colleague, but we're saying he is personally responsible. I expect him to file an affidavit, deal with the facts of his case. He hasn't done that, and that must go against him, because he has not put facts before this court as to why he should not be responsible. That is actually, yes, the 8th respondent. He simply relies on what the 9th respondent says in her affidavit. But this is a case where we're asking for personal payments and personal accountability. He could not do that, and he must not be allowed to do that. My lady, the counter application. You asked my learned friend to address you on the jurisdiction. He says, in any event, the SABC is here. Meaning, we are taking the report of the SABC, they are before court. But again, that does not emanate from investigation of the SIU. And the question is, and he says now it's a collateral review, but what is the coercive action that we've taken against his clients on that report? What is it? One doesn't simply throw terms in the air like collateral review. You've got to assert, this is the coercive action that I'm facing. It is based on this internal SABC report. I have said at the beginning, that is not what we are relying on. We come here based on the SIU investigation, and our record shows that. So this notion that this somehow qualifies as a collateral review is with respect misplaced. And on the striking out, we don't need to show that there's prejudice. All that we say, the allegations are vexatious, they are irrelevant, and one need not be a nuclear scientist to see that. You are telling us about things happening in the labor court. What do they have to do with us here? And now we hear that Ms. Dreyer committed perjury. Again, what is the basis of that? How does counsel make such a submission when there's no basis laid? You are not told where is that perjury, and if so, why have they not reported to the SAPS? Because this court is not here to investigate criminal allegations. You must go to the SAPS and lay a claim if they believe they have a case of perjury. But all these arguments for the ninth and eighth and ninth respondent, really, they leave a lot to be desired. The sixth respondent says, we take no issue with the review relief. But then the sixth respondent comes and says, the terms of reference are not signed. Therefore, but the question is, and of course what we have in the record is unsigned terms of reference. But what is the sixth respondent saying then? Is that a concession that the decision taken by operations committee is unlawful because of unsigned terms of reference? So as I understand the argument, then it supports the relief that we seek, if it's correct. But again, why didn't he dissent? But people, how can we operate on the basis of an unsigned terms of reference? And I will say, even if others may not be held accountable, this sixth respondent, based on these arguments, my lady, with respect, the sixth respondent must not escape. Must not escape. And these are the unmeritorious points in limine I'm talking about. Technical points that instead of dealing with the issues, we raise unmeritorious technical points simply to waste the court's time. That should not be countenanced. Again, the ordinary principle, those decisions are in any event valid in law until set aside. But that's why we're here, and we say they must be set aside. And then he raised an argument that the sixth respondent did not waive its rights. We've never asserted any waiver. We've never raised that argument. I'm not going to respond any further to that. Of course, he says no resolution was made on 26 July. That while others are saying it was made on 26 July, but the evidence is there. Clearly, they were simply noting that we don't have an issue with. And the argument that the sixth, there's no evidence that the sixth respondent participated in the discussion. But that is not what clause is it 30? I'm now forgetting that clause that we rely on.
523.
Yes, and I want to deal with that because everybody says, yeah, but you raise it in the reply and so forth. Well, firstly, it was raised in the heads in July last year. In July 2021, it was raised. And let us understand this. And it is the issue these days that we were taught that when you do affidavits, you don't plead the law, you plead the facts. And my argument is that, yes, you may criticize that it was not mentioned, but this is a legal prescript. It's a legal prescript, and one must not conflate factual arguments with legal argument. It was properly made in the heads. It was properly made in the reply. If anyone had an issue with it, and Mr. Butlender says they could have raised a collateral review, well, they didn't, but they've been aware of it from July 2021. They've all been aware of it. They took no steps.
This is an internal policy document. It's not a law of general application, Mr. Motepe.
Well, the Constitutional Court in all pay has made it clear that all these legal prescripts, they are a legal foundation of a decision. So we do not simply deal with them as though they are not the law. Those and Justice Frenneman says that they are not mere internal policies. They form the legal framework of a decision to be made. And that is why Mr. Butlender says, look, if we're aware, we would have challenged this collateral because he knows it's a legal prescript. So that's our argument in relation to that. The 10th respondent obviously pasted with prescription. I've already submitted that. The Companies Act, our course of action is not based on Section 77 sub 7, so we're not going to deal with that. But that is linked to the prescription point. I've already dealt with the prescription. It cannot hold. And then the second respondent says she thought.
Is 7.7 not being raised here as a defense?
But my lady, all I'm saying is that the same argument I raised in relation to prescription, because it is the other side of the coin to prescription. Remember, it says you can no longer claim against a director if this happened more than 3 years ago.
Yeah.
My argument is that because of the ordinary principle, the decision that we attack now was valid. It's still valid as we sit here. We make an argument that it must be invalidated. But in law, it is still valid. It exists and it has led to legal consequences, and it will still continue to do. Until that decision is set aside. Until it's set aside, how could we have pursued any of these individuals for repayment until it is set aside? And that is why you need to firstly have it set aside because of the ordinary principle, as confirmed in Kerland and other decisions. And that is why prescription and this section 77, they cannot assist the respondents in this case. We firstly had to come to court, have the decision set aside, and then under just an equitable remedy, claim the relief. There is no way we could have issued summons. A simple special plea that you had claimed does not even exist in law would have hit us, or an exception for that matter, but there's no cause of action.
But the delay point is raised in respect of the review, not any other cause of action, the review.
No, but my lady, the prescription point, and my lady, there's conflation of the two concepts. There's a prescription point which goes with section 77, which says you cannot sue us except if it's within 3 years. And I am saying that relates to the just and equitable remedy. That's what they say, to the repayment.
Yes.
But I'm saying, how do you then go and claim from them when in law there is a valid decision to say there is proper payment to be made to the legends?
Isn't there a knock-off effect if you delay in instituting the review where the declaration of invalidity will be made? That has an impact on the remedy.
Yes, no, that I agree with. That I agree with. But I'm saying that is a pure administrative law principle. And if one is going to apply Gijima and Buffalo City, if your leadership finds that the facts are applicable, and your leadership is entitled, is perfectly entitled then to come up with a remedy of that nature. But that does not mean it's a prescription point. That's the point that I'm making. Until that decision is set aside, we could not have issued summons. It's impossible in law. Well, we may have tried, but there's no cause of action because we would have been saying in the pleadings that you improperly paid the legends, and the exception is going to be, but there's no cause of action. You have not challenged that decision is valid in law, and that's the point, my lady. That is a different point to the delay point in where administrative decision is challenged. That is different to prescription and section 77 sub 7 of the companies.
Let me ask you this question differently. Why on these facts should I overlook the delay for the purpose of the remedy?
And I've addressed that, and I've made a distinction with so to say, firstly, in reference to SIU versus ESS, this case that I gave reference earlier today, where the SCA refused to overlook the delay. And it said, we do not even have to go to the fourth requirement as set out in Buffalo City because there is no merit in the review. So there is no merit in the legality challenge. But if there was merit in the legality challenge, the SCA would not have had a discretion. They would have had to assess the Gijima principle that even where the delay is not properly explained, the court is unhappy, In terms of the Gijima principle, this court may still have had to set the decision aside. And this is also explained in the we've referred to Mott McDonald decision. I'm not going to read that decision, but it appears at
Yes, I'm familiar with it.
Yes, and it's also analyzed. But that's the issue, my lady. We and again, the delay must be understood at least on those two aspects. Firstly, the legality review, but on the just and equitable remedy. And then we say that there is no reason why this court should not overlook the delay so far as the legality review, legality challenge is concerned. Secondly, there's no reason why this court should not overlook the delay, even in relation to the just and equitable remedy. We say, and I repeat that if we are wrong in relation to members of the Ops Committee simply because they are members of the Ops Committee, we are not wrong in relation to those who signed the business case, and now the sixth respondent who raised unmeritorious point that terms of reference were not signed. And we say, at least on those, because the court has got a wide discretion, it looks on a variety of factors. Where you have a deponent, even today, still asserting that which has been unproven or proven to be incorrect, still asserting that all those factors, this court can take into account. There's simply no admission that, you know what, I was wrong. I was expecting funds from multi-choice, they didn't come. Nothing. And we say, even if you find that in relation to OPSCOM members, your leadership is not going to order repayment, even if you find that. But in relation to at least the 3 respondents, but now the 6th respondent we submit has placed himself squarely in that bracket, raising this unmeritorious points of terms of reference. We say against those, my lady, we have a case, and then there has to be repayment. So far as the costs are concerned, we obviously the costs necessarily will have to follow the event, but all those who oppose firstly the legality point must pay our costs. And in fact, we say they must be marketed with costs of this entire application, because if there was a concession much earlier on, we wouldn't be here. And perhaps the issue of just an equitable remedy would have taken a different angle. But we come here because people are still trying to defend the indefensible.
Okay, I'd like to understand your point on costs. So are you saying, when you say that those who opposed the review should pay the costs, are you speaking to the question of the scale of costs, or that aspect of they should pay the review costs, the costs related to the review, as well as the costs related to the remedy? Or
yes,
are you addressing the question of the scale?
Yes, and I must be understood.
Yes.
I am not abandoning relief against all the OPSCOM members.
Yes.
So I'm raising this as an alternative. That firstly, the cost will follow the event. We succeed, all the respondents must pay the costs.
Jointly and severally?
Yes, if we succeed on everything. But if your leadership finds that there is no order of repayment can be made against only those who oppose that order, against only those who oppose that order, we say in that case, it is not us who must pay their costs. It is still those who opposed the review point. They must pay the cost of this application. Either. But they are the ones who took a decision. They are the ones still trying to defend this decision that is indefensible. So they must pay the costs. But the main point, of course, is that if leadership is with us in all these aspects, then all the respondents must pay our costs. Those are our submissions, my lady.
Ms. Nyati. Thank you, Mr. Mutape. Is she still here? Ms. Nyati. Okay. I'm declaring the proceedings to have come to a close. I'm very grateful to counsel for your assistance. I am reserving judgment. I'm unlikely to hand it out in open court. I'm most likely to hand it down electronically. And when it is ready, it will simply be handed down in that manner.
Thank you, my lady.
My lady, could I just say, I don't want to make more submissions, but my learned friend has now tried to argue that raising clause 5.2.3 in reply is good enough. I'm not going to make submissions on that unless your ladyship wants to hear me on that. But I'm happy to say something if you deem it necessary.
Okay, proceed, Mr. Bucklander.
My lady, it's an extraordinary proposition because it's not a point of law. It's a cause of action. What my learned friend does is he doesn't rely on the law of delict, he doesn't rely on the law of vicarious liability, and he doesn't rely on the law of the Companies Act. He relies on clause 5.2.3 to create a nexus between his clients and mine and the others. Now, that's not something you can plead in reply, and it's not something you can plead in the heads. It's a cause of action point, and it ought to have been pleaded in the founding and supplementary papers. That's point one. Point two, he says it was raised in the heads. My lady, it was raised as a one-liner in the midst of 60 pages of heads. It's now become the sum total of his argument for personal liability. We could never have anticipated the focus on that. And with respect to say it was raised in the heads is vastly overstating it. So, but your ladyship knows the law. I don't need to belabor the point that you make out your case in founding, not in replying. And there's simply no basis for it. So I don't want to delay the court further, but it's with respect no answer at all. And my learned friend knows that.
Thank you, Mr. Bucklander. The proceedings are adjourned.
Thank you, my lady.
Thank you, my lady.
As please the court, thank you, my lady.
As a court, please, thank you.
As a piece of the court, my lady.
Thank you, my lady. My lady. Thank you, my lady.
Thank you.
Thank you, my lady.
Thank you.